conclusion of the Anti-Money Laundering and Countering Financing of Terrorism Amendment Bill, or at 6 p.m, whichever is earlier.
Leave is put for that purpose. Is there any objection? There appears to be none.
Mr Chairman, Mr Speaker, thank you. The Labour Party is supporting this bill to select committee. Sir, I want to endorse the Minister's comments that, of course, no political party in this House wants to see New Zealand abused as a centre for money laundering, and make a couple of more general points before referring to the specifics of this legislation. Sir, the first point to note is that it's pretty clear that New Zealand has been used as a place to launder money. I think that was made clear from the Panama Papers, which disclosed that offshore trusts investing money outside of New Zealand through trusts that were operated from New Zealand were at times being used to hide money that was being invested through those trusts from the authorities in the home countries from which the beneficiaries of those trusts came. And some of that was legitimate, in that some people didn't want their financial affairs disclosed to the authorities back home, but they weren't doing anything illegal. Some of it was about tax avoidance, and it's pretty clear that we've got a big problem around the world with some of the 1%ers in the world. Notwithstanding the fact that they have more wealth than everyone else, they seem determined to pay lower rates of tax than middle-class people in most countries. And that was bad, and that was being facilitated through those trusts. And then the third class of transaction that I'm sure was occurring was the laundering of illegal money, money laundering from proceeds of crime. And that money was being invested overseas in a way that was not transparent to law enforcement authorities around the world, because the opaque arrangements in respect of New Zealand-based trusts investing money offshore of New Zealand was not clear enough. And at the time, the government said there was nothing to look at there. They had a report by John Shewan, and he came back and said, yes, the criticisms were true, that New Zealand was being used as a destination for those improper transactions, and it's to be hoped that we tidy that up and adopt the recommendations that John Shewan recommended. Now, this legislation is slightly different in that it's looking at investments that are made in New Zealand rather than outside of New Zealand using New Zealand-based trust transactions. And this Anti-Money Laundering and Countering Financing of Terrorism Amendment Bill, as the Minister says, attempts to do that by extending the purview of the Act to, amongst others, accountants and lawyers who aren't currently caught by the Act, and then makes other changes that the Minister has averted to. Now, the Minister said that the 10-year cost of compliance as originally designed was $1.6 billion, which was worked out to be $160 million per annum, and says that the revised estimate, given changes that have been made, is between $800 and $1.1 billion over 10 years, which is between $80 million and $110 million extra compliance cost for New Zealand businesses per annum. It's a not insignificant sum. If that $100 million per annum was being spent in another part of the economy, well, it could go a long way, whether it was to alleviating some of the problems that we've got in housing through perhaps a greater support by government of those sectors, or indeed just through people having that extra money in their businesses to spend into the economy, which would go around. So we should be careful when we're imposing new requirements that we are actually meeting the purpose without imposing extreme or overly higher costs than is warranted. And I want to give an example of where I think, two examples where in the last decade we've gone too far in respect of regulation of the financial services. And the first is in respect of financial advisors. Post the collapse of finance companies and the losses that were suffered by people who were investing in those finance companies, this Parliament chose to look again at the regulation of financial advisors and imposed further regulation upon them, and some further regulation was necessary. But we got to the ridiculous point in this country that we said that some of the people who are logically financial advisors through the decades, like lawyers and accountants, could not act as financial advisors to the people that came in their office without going through this great hoopla that they couldn't or wouldn't go through. And the net effect of that was brought out when the government, in the view of the Labor Party, wrongly, sold down shares in the major energy companies, Meridian Energy, Mighty River Power and Genesis Energy. Because so many of the people who were left as qualified financial advisors were conflicted because they were acting as brokers for the government or as agents for the brokers that were appointed to the government, there was virtually no one left in New Zealand who could legally give financial advice to New Zealanders as to whether they should or shouldn't invest in those shares that were being sold by the government and those energy companies. The people that were conflicted were virtually all of the major share broking houses in the country, plus all of the banks, who were the other route. It meant that, in practice, the ability of New Zealanders to get sound advice from financial advisors as to whether they should invest or not was prevented because of the over-regulation of who could be a financial advisor in the legislation that was passed by the national government, actually led by Simon Power, post the finance company collapses. The second example I'll give is in respect of the over-regulation of ordinary capital raising. Now, there have been some good things done in respect of ordinary capital raising, so I don't want to say that it's all bad. Small capital raising through crowdsourcing of relatively small amounts of money, actually the appropriate limit for crowdfunding, has been allowed through changes to our securities laws in recent years, and that's a good thing. But the over-regulation of the raising of ordinary capital by small to medium-sized companies, or mainly medium-sized companies that are growing, has meant that very few of those companies are now raising money from the public. So why has that happened? Well, it's because directors' duties have been increased. So if you're an experienced director, your director's duties in respect of the money that an investor invests in an ordinary capital raising, your risks are heightened compared with what they were in yesteryear, and they're now so high that you can't insure against those risks. You can't, at a realistic price, get insurance against liability for prospectus risk in New Zealand. And the consequences of this has been that these very companies that we want to have a low cost of capital when they're fundraising in order to expand as they exploit some of these global opportunities arising from new technologies cannot raise money from the public. So instead of regulating and properly describing risk to those people who are proposing to invest in shares, we're actually stopping them doing it because no one's using that route now because it's over-regulated. And that's got to be an absurd policy outcome. So, Sir, coming back to this legislation, I'm worried, and I think the Select Committee should be ascertaining whether in pursuing the ambition, which I think everyone in this Parliament has, that we should be countering laundering and money laundering and the financing of terrorism, that we're not going so far as to impose a silly level of compliance which really doesn't achieve much more in the pursuit of anti-money laundering, but nonetheless sucks out of the economy $100 million per annum in compliance cost. So I probably won't be on the Select Committee considering it, but I would hope that the Select Committee that considers it really drills down into that. Will this achieve its purpose, or will it, as in those other two examples that I've given, over-regulate this space at the cost of the New Zealand economy and make us a more expensive place for no real gain? Sir, with those comments, can I say that the Labor Party supports the ambition of this legislation to clamp down on money laundering, and note that we are supporting this at first reading. Thank you, sir.
Mr. Speaker. Kanwaljit Singh Bakshi.
Thank you, Mr. Speaker.